हाँ देखो देन चल रही है चलो.
etc. etc. They have not been able to segregate despite 2 years of investigation. And then learned single judge who had the access to that report has in his para 71 and 72 specifically noted, which I read before Lordship, that the latest recommendations or decision dated 28/6/25 does not inherit the larger challenge posed by the petitioners regarding the sanctity of the examination. Instead, this recommendation decision, which was made in response to the broader challenge against the compromised sanctity of the sub-inspector recruitment examination 2021, actually serves to strengthen the contention of the petitioners and make them corresponding prayers more robust. This particularly so because the further investigation, as detailed in SIT, forms the basis for which the said recommendation decision dated 28/6 highlights the existence of large-scale malpractice in the conduct of written examination and decision dated 28/6/25 bolstered certain prayers of the examination process. On this was given, they are filing charge sheets one after the other, and yet they reverse that. So then, charge sheet 7I was filed, sir, by the SOG, in which further a Haryana gang member was involved, sir, by the name of Kamal Yadav, who died in unknown circumstances. I'll just take a lordship to page 376 for this, sir. 376 of the appeals. So the two charge sheets were handed over by the state to the learned single judge when on the time when the judgment was reserved. Which has been filed as annexure R/5/1 at page 364. I am reading at page 376. I am reading at page 376, sir. Just one little portion. Now, after having given the second report, it is still, this is what the SOG report says. It says there were 5 modus operandi which were there. Rajasthan police bharti pariksha में अयोग्य अभ्यर्थियों के चयन की modus operandi. It is page 376. 376.
Hello.
376 of what?
Appeal. DB appeal. So because these were handed over actually at that when the judgment was reserved. Amar Singh's appeal.
Appeal 376 is not there.
Sir, there is a
Hence,
application. Sir, application has been filed because they were submitted when so this application was filed by me to bring on record these 2 charge sheets handed over by the learned single judge on the day when the judgment was reserved. Lordship, I believe, observed that these will be considered when you are during the course of your arguments. So
this you had filed before the signature.
in the last line of para 15, he said, spoke to Supreme Court that he frankly admitted as well that in process it might not be possible to identify each and every beneficiary of the malpractice perpetrated. On a consideration of a revelation of the course of investigation, we have the view that the examination indeed have been exposed to deep rooted conspiracy of gang of persons who, with the aid of electronic devices, have been able to access the beneficiary candidates with the answer keys during the test so as to enable them to solve the question paper. This, as the investigation disclosed, was on the basis of premeditated design and benefit has been extended as monetary consideration. These, we hasten to add, are gathered from the status reports submitted before this court from time to time, the authenticity whereof has not been questioned. The disclosures to state that at least are starting and alarming as well. The status report disclosed involvement of persons who have been similarly involved in such strategy and are the beneficiaries thereof. We have noted that the investigation of the case of registered has progressed well, and with regard to the magnitude of the exercise involved, we accept that some time would be necessary to complete the same in all respects. Situation thus is the same. Don't you skip 17, come to 18.
No, that is important.
Okay, 17.
That is what is behind the court's mind.
Situated thus with the time schedule fixed by this court for completion of the admission process for the first MBBS BDS courses as per the pronouncements made in Dhar, Union of India and P.H. Gupta versus State of Chhattisgarh, there are presently 2 alternative courses. Either to segregate the 44 already identified beneficiary candidates, direct their results to be withheld and permit CBSE to proceed with the process underway, or direct a fresh examination by cancelling the ongoing exams. As has been noticed here above, the disclosure in the investigation suggests that the benefit of answer E has been availed by several candidates taking the examination by illegal means. Though as on date, 44 such candidates have been identified, having regard to the modus operandi put in place, the phones and other devices used, it is not unlikely that many more candidates have availed such undue advantage and the process has been unduly benefited for the other students who have made sincere and genuine endeavors to solve answer papers on the basis of their devoted preparation and hard labor. In view of the widespread network that has operated and the status reports disclosed and the administrative persons arrested, including some beneficiary candidates, we have the opinion, in view of the strong possibility of identification of other candidates as well involved in such malpractices, that the examination has become a suspect. As it is, the system of examination pursued over the decades has been accepted by all who are rational, responsible, and sensible to be credited to one. For comparative evaluation of the merit and worth of candidates vying for higher academic pursuits, it is thus necessary for all the role players in the process to secure and sustain the confidence of the public in general and the student fraternity in particular in the system of this unquestionable trustworthiness. Such a system is endorsed because it is its credibility informed with guarantee of fairness, transparency, authenticity, and sanctity. There cannot be any compromise with these imperatives at any cost. And having said that, it comes to, what should I come to 23, sir? We are aware in 23. We are aware that the application examination will result in some inconvenience to all concerned and that some extra time will be consumed for holding a fresh examination with renewed efforts. Therefore, this, however, according to us, is a price that stakeholders would have to suffer in order to maintain the impeccable and irrefutable sanctity and credibility of a process of examination to assess the innate worth and capability of participating candidates for being assigned into, say, merit position commensurate. And last paragraph, they say that the petition was allowed. And about, I believe there is an argument raised.
Yes.
In 26, there is an argument raised that any observation by the High Court would sort of pre-catch the culpability of the involved. In this case, they have Supreme Court clarified in the last paragraph, saying, we reiterate that the references to the status reports and the content thereof so far relatable to the cases in hand have been only in the context of the adjudication of the issues involved herein and have to be construed accordingly. So therefore, this observation of the High Court not affect their trials. Now, Lordship, coming to the Besaki Bhattacharya, which is the star case in this case. So, in this volume 2, page 1. Volume papers. And this one is different from 3rd of April 25 and High Court April of 24th of April 24. This one is next process of 2016. Context there was school commission. I will read the first program. It's one paragraph which give the background. Second paragraph is improving judgment in 2022 for particular blocks society 2016 selection process conducted and involved secondary school service selection for the recruitment of non-teaching staff in group CD and assist teachers from class 9 to 12. The applicant was selected, some of whom have been working over 5 years. They fall into categories selected to purport evidence and make it wrongly. And other selectees claim that they were validly selected and have committed no wrongdoing. The state of West Bengal School Service Commission has also challenged the response given as the petitioner from succeeded before the High Court Calcutta. CBI, which carried out the investigation from the direction given by the High Court and Calcutta also arraigned and responded. Then we can selecting the challenge the judgment of the following main ground. First, then the evidence against them is weak, unproven, and inadmissible. Second, they were punished without an inquiry, violating the principles of natural justice. Third, while they were charge sheeted, they have not been convicted and should be treated as innocent. The other selectees, the state testimony and convincingly argued that the High Court erred by having the entire selection process based on the CBI report and should have only cancelled the appointments of those found guilty, leaving the other appointments intact. This is exactly what your doctrine had raised. That was the question also looks on its view. And they said that the evidence was in this, the number of candidates was about 25,000. Only post 25. From the next post 25. I think 800. They were 25. And they have been serving 16th election, cancelled 25. That's the same. And how much come to? 17. The legal position in which the judgments have been rendered. And this is the of the judgments which reported.
Yes.
So the legal position starting from para 7. Now this report has all judgments Sanjay Kumar para 8, Board of Education and Ramsham, last sometime para 9, Amika Mishra para 10, and Puttu Adi in para 11. Para 12 is see that in the things which has been developed by my learners during the programs. This is that I will.
Yes. 30. Yes.
This one, see, this one is for the idea to cancel for. The first, there must be sufficient ground, sufficient written vehicle to enable the state to review that selection process. Second, to determine whether it can be go to the root of the matter and initiate entire selection process. Such type of information will be based on a recent and foreign verification. Third, there must be sufficient detail to support the competence of the majority. The three topics, as outlined by Sinha, appropriate and should be adhered. The custom of the law involved very effectively recovered masses of cash from house and share PSC. The allegations related to Federal served from 96 to 2002 had made self appointment between 98 to 2001 for extraneous consideration. Affected account whose sport whose services were available comprised for carrying the officers related to 4 recruitment examinations held between 97 to 2001. 2 FIRs can be registered against the chairman and officer of the PPSC. However, among the selectees and FIR was found only HS1. In this factual background, in the given distinction between a proven case of mass cheating in a board exam and an unproven charge of corruption in the context of a civil servant. Spread over 3 to 4 years to reverse. This was an unprecedented case of mass separation with a following impact and consequences. Applying to the 3-court actual and legal test on mass termination was set aside in this context to observe the termination orders only issue in cases where it is found to be impossible or highly improbable to separate the tainted cases from the non-tainted ones. In our present view, the opinion expressed by Justice Bhaerti and Segregation regarding the strict compliance with the requisite is not in line with the issue of the highlights in the bench decision in Bihar school examination. We like to observe that on mass termination in the case was based on the charge of corruption against the former chairman, leading to the cancellation of the entire subject process. And the appointments, even though the charges against him had yet not been proven in the court of law. Similarly, another thing is Joginder Singh was on the book. In Joginder Singh, the 4 observers made to separate taken for the found that possible. Cancellation of the entire sex process incompatible with law. And then the last case that was quoted to Bhaerti average star at 18. This one of a good system must be adopted by SSC and the extent of unfair means he would and whether it is possible to separate the tainted content from the untainted one. The court must ensure that allegations of conduct are substantiated and that the victim of record including investigative report supports this conclusion. There must be at least some evidence from the court to be such a conclusion. However, the standard of evidence need not be unduly strict. Specifically, the written on record need not point to a single definitive conclusion that malpractice occurred at a suspect level. Nevertheless, there must be a real possibility of systematic malice as reflected in the detail before the court. Now, the principle that I am the following principle emerged from the course of discussion when an in-depth factual inquiry reveals systemic irregularities such as malice or fraud that undermine the integrity of the entire selection process. The result should be cancelled in its entirety. However, and when possible, segregation of untainted candidates should be done in consequence with the fair selection. The decision to cancel selection on mass must be based on the investigation, satisfaction right with sufficient material, collected through a fair and thorough investigation. It is not necessary for the material collected to conclusively prove malpractice beyond a reasonable term. The standard of evidence should be reasonable, certainty of systemic malaise, the probability at rest is happening. Despite the inconvenience caused to untainted candidates when broad and deep manipulation in the selection process over, due weightage has to be given to the maintaining the purity of the selection process. Individual notice and hearing may not be necessary of cases for practical reasons, and the facts established when the class which is initiated with illegalities at a large scale. So these are the four principles I have to find out. And then I come to the arbitration. In this, what is it? 44 agreement? It's actually a technical objection, but delay latches and natural justice that have been dealt with that 43, 44, that they came till into and then came. So that I think in the overall context of what is happening, Lordship may like to. I'll read this. The SEC and the cadets have raised the estoppel delay and latches in filing the petition in our view. The court judgment characteristics dismiss these pleas, relying on the court judgment and so and so. The judgment distinguishes between acquiescence, delay, and latches, noting that they have distinct characteristics, though the underlying principle remains one of estoppel. Latches refers to the remissions or slackness involving unreasonable delays or negligence in seeking equity, usually the other party. It arises from the neglect of a party to assert their right, thereby preventing them from seeking indeed. In our opinion, this bar does not apply here, as the fraud and irregularities were only uncovered in 21 and 22. Applying the limits of latches, which is not a statutory bar, would be contrary to the equity and justice in these circumstances. The principle of acquiescence also does not apply, and it assumes knowledge of the act, followed by the passive acceptance. Therefore, it introduces a new implied defense that does not fit the facts of this case. Delay as a general principle encompasses both latches and acquiescence, and delay is always fact specific. In this case, where fraud was concealed, as well as a cover-up was practiced, these principles cannot be applied. We have already partially addressed the failure to adhere to the principles of natural justice while examining the applicable case law. It's also important to emphasize that in this case, public notice were issued, and the candidates, applicants, petitioners were afforded the opportunity of prescribing the data and present the arguments. In light of the facts of the case, we are of the opinion that the principles of natural justice cannot be invoked to validate the fraud that has occurred. These principles are not rigid or inflexible. Rather, they must be applied with due regard to the specific facts and circumstances of the case. Lordship may now come to conclusion from 45 to onwards. The last question remains to the whether it requires any modification. We find no valid ground or reason to indicate in the direction of the High Court that the service of the tainted candidates were appointed must be terminated and they should be required to refund any salaries payments received. Since their appointments were the result of fraud, this amounts to cheating. Therefore, we see no justification to alter this direction. For candidates not specifically found to be tainted, the entire selection process has been rightly declared null and void due to the egregious violations and illegalities where violated Article 1460 of the Constitution. As such, the appointments of these candidates are cancelled. However, candidates who are already employed need not be asked to refund or restitute any payment made to them. However, their services will be terminated. Furthermore, no candidate can be appointed once their entire examination process and results have been declared void. Some of the appointed candidates who do not fall within the category of tainted candidates may have previously worked in different departments of selection, state government or with autonomous bodies, etc. In such cases, although their appointments are cancelled, their candidates will have the right to apply to their previous departments or autonomous bodies to continue the service in those entities. These applications must be processed by the respective government departments or bodies within 3 months, and the candidates will be allowed to resume their positions under the period of termination of their previous appointment, and the rejoining will not be considered as a break in service. And the seniority of the entitlements will be preserved and they will be eligible to implement. However, for the period they were employed under the disputed appointment, no wages will be paid by the state government or autonomous bodies. Further, if required and necessary, superintendent post may be dated to present person's point on this. Then 48 deals with the disabled candidates. 49 says the same thing. The disabled candidates mentioned in the previous paragraph will be allowed to participate in fresh selection process. They require age relaxation and other concessions. Similarly, other candidates who are not specifically allocated will also be eligible to participate with appropriate age relaxations. In our opinion, such action will be fair and just as it would allow these candidates to take part in fresh selection process, which should not be initial in the cases. So they gave age relaxation. Those who are left service can go join back, no break in service, and fresh examination. This is what they like. Now there is a new file in this case that came to be so just a week and a half. I think actually it is dismissing that basically. So I'll not go to this. No, just last two judgments about molding the leaves. Because they said it has become infructuous and those technical leaves. So First is M. Sudhakar versus V. Manohar. In this case, it's a case of a trust which a person has to be barred from.
Again, what do you want to say regarding molding of relations? It can be done, that is all.
So, in the person, it comes across to all the factors in one case. Then,
Come to the illegalities in this case.
legality.
Illegalities in this case of Ramesh. This Bhattacharya. Para 20. Para 20.
Right. That's initiated taken beyond resolution. Many places in fraud on a large scale coupled with attempted cover up have dented the selection process beyond repair and partial attention. The continuity and legitimacy of the sanctions are denuded. The High Court has referred to illegality in the included center. Evidence-based reports have established the following illegality in the selection process. SSC has appointed an agency named LISN for public scanning and evaluating the home sheets by closed loop payment processing violation of Article 14. Such agency had engaged other agency named data scan OMR sheets. Although scanning was done at the office premises of SSC, came by SSC, that SSC never engaged data scan to scan the OMR sheets and or filed NISA to engage data scan foreign agency. SSC has destroyed the original OMR sheets, ostensibly scanned the image thereof being preserved in the server. CBI did not find any scanned related to the OMR sheets that server SSC. OMR sheets have been destroyed without the scanned images being preserved in the server of SSC. SSC had provided scanned OMR sheets to RTI applicants in year 2018. Till 23, claiming that such OMR sheets were from its database, although CBI did not find any OMR sheets in the server of SSC. Appointments higher than the declared vacancies has been given with respect to the four categories. Appointments have been given to persons who are not even the panel. Appointments have been given to persons who submitted blank OMR sheets. Appointments have been given to persons after expiring the panel. Persons placed lower in rank have been given appointment to persons placed higher in the rank in the merit list. Merit list containing the marks obtained by the respective candidates had never been published. Counseling had been held subsequent to the expiry of the panel. Total beneficiaries of the illegalities are yet to be identified and rendered in court. Probably given the stand of SSC board and state, SSC has applied for motion to create supplementary posts to accommodate the illegal appointment. Recruitment rules governing the four categories had never been adhered to, either in that or field. The aforesaid established irregularities cumulatively and incrementally demarcate the contours of the court to navigate the review sought to ensure the clarity and objectivity. We shall independently examine the facts and forum of people. So, these have brought out the.
These are not cases of paper leak.
No, this is not a case of it. You know,
It's not a case of
no,
It was relating to the illegalities committed by the examining body itself.
Sir.
Relating to the OMR sheets being, relating to scanning being alleged to have been done but not done. There was no documents available. Merit list was not prepared. People, merit list was not prepared. The persons who were not there,
Sir.
who had not even participated, there is a list here in the next meeting.
Yes.
Where they have been appointed, they have jumped. Those who were not in the panel itself, they were also appointed.
Yes.
So it was not actually a selection process at all. It was a sham. It was virtually an example. Selection process was a big sham. And therefore they cancelled it. They said even you talking about tainted and untainted, even those who are tainted or those who are untainted will all go because the examination itself was a sham. The other, Varshika Yadav versus Union of India. There was a malpractice. All right. We will go through these judgments. We'll go through this.
In summation, it will very brief. Sir, one is it starts at the RPSC and your lordship goes through WhatsApp. Now, WhatsApp, one might say it's the passenger who are there, but the person who is paid, he will have to recover his money. And WhatsApp, once it goes, there is no way you are going to which way is like in the report is like a mining vein underground. Where it goes, the main thing is still abroad and still missing. 82 named in April 25 are now 89 and they are still pending. And the day is missing, then the essentially for FIR filed in 20, now it is 20. Arrested. 38%, otherwise 68 or 16. That is not very interesting. It is left open. Then they start going to thanas and they're handling public affairs and then something is going there the vendors. The point is that the sanctity of this examination, the faith in this. When people fight in each other, they say, I go to court. But court is step 2. Step 1 is police court.
In many of the cases, High Court questioned and the Supreme Court set aside. There are judgments now. This is what we are. We'll have to conduct an exercise.
Yes, exactly.
All right.
Now,
Anything else?
last point. Just last one. Now, Chief Justice Bags, on his first foundation of group 1, I just put 3 lines that he said, he also authorized it. When Justice Sanjeev Khanna. When examination papers are leaked, it shatters the dreams and aspirations of all students across the country, deeply affecting public education right and the ability to secure jobs. Each instance of such corruption directly diminishes our capacity to test and support the most vulnerable citizens. This in turn diminishes public trust. So it all relates to public trust, particularly the police examination. I didn't mean clerks, it's probably very different, but police has to be seen to them more. That's it. Okay.
Anything else from this side?
My lord,
Or we conclude?
my
You
lord,
want to say?
two,
Yes.
three things, my lord,
Okay.
because certain on maintainability issues, my lord, finally,
Hand over that, what, Justice CJ is,
it's an emotional appeal to your lordship. It's an-
that's always a part of the argument, sir.
Yes, my lord.
It has to be.
It's an emotional
It's a-
appeal argument, my lord, which I will like to, my lord.
All right, you also make your own. Yes.
Or Manish was.
Here, keep.
Finally, my lord, after being encountered on issues of maintainability, concealment, etc., my learned friend said that I was from very beginning wanted, let Pramod's file be seen. Because it has been filed in 2023 and therefore, if the Pramod's case can be examined, in that event, why the issue of maintainability in this case should be examined? That is what he has submitted, my lord. Now, I would, my lord, firstly seek indulgence of your lordship to the judgment of this honorable court. Is there any argument made on behalf of the counsel for Pramod Kumar's case which has been dealt with? In the entire judgment, my lord, अपील नहीं एसबी के जजमेंट की बात हो रही है सर, वही नंबर क्वेश्चन है.
With your lordship's permission, sir.
Yes, yes, yes.
So in the, my lord, entire judgment, Pramod Kumar case submissions or nothing has been dealt with as to how the Pramod Kumar's case is sustainable and this Kailash Chand is not sustainable. Number one, my lord. Secondly, this argument has not been raised before the Honorable Single Judge, nor the Single Judge has turned down the issues of maintainability on the ground that since a Pramod Kumar's case is already filed in 2023, therefore we are entertaining Kailash Chand's case. That is not permissible. Secondly, my lord, in Pramod Kumar's case, my lord, the only question of maintainability which is not there is concealment of the fact. Rest all other arguments your lordship may have Pramod Kumar's file, my lord, 12435 of 2023 and appeal number appeal is 1405 2005, my lord. In this your lordship may see the writ petition, my lord. There are 6 petitioners. They seek cancellation of examination held in the month of September 2021. They got selected in the written examination, my lord. They passed the physical examination. They appeared in interview. And thereafter, when they didn't find their place in the merit list, my lord, they come to this honorable court.
Pramod Kumar.
Pramod Kumar. Your lordship may just have 6 petitioners. Interview letters of all the 6 petitioners have been filed on record by Pramod Kumar. So it is after the result is declared in June 2020. Item 217.
The page is on 78 to start with.
There are 6 petitioners, my lord, and your lordship will find copies of interview letters from 91 to 102 of all the 6 persons. Annexure 6, my lord. So they appear in the interview, my lord, which was conducted from 23rd of January 2023 to 30th May 2023. And then, when the result is declared, which they have submitted on record as Annexure 11 on 1/6/2023, in the month of August, my lord, they filed this petition. Now, in my compilation, my lord, I have submitted the impact of delay and leakage in these recruitment matters as flag 13 and 14, my lord, the judgments in case of Lakshmi Narayan Das and Shiva Shankar Mohapatra. So I am not elaborating on that, my lord. What I am showing is clear case of not only delay and leakage, my lord, clear case of acquiescence, because before these interview letters they have submitted FIRs and charge sheets which have already been filed. The lordship may appreciate it is not, my lord, that in 14th September 2021 itself FIR was registered. Challan was also filed. Before this, they appeared in the interview. In earlier writ petition of Kailash, my lord, we have said that out of 10 FIR registered, in 5 charge sheets were submitted and in 2 FRs were submitted. Irrespective of that, Kailash Chand and the others who filed the petition, they withdraw it, conceal it and make a false statement to the effect that they haven't filed any petition. Now, how does he explain the delay, my lord, your lordship? Very interesting two-liner. Ground M at page 8 of the petition, that there is no delay and leakage in the filing of this writ petition by the petitioners. Ground M at page 8 of the petition, my lord. Ground M. That there is no delay and leakage in the filing of this writ petition by the petitioners. So they don't say, my lord, that they didn't know anything earlier, now that the fraud has been disclosed and therefore we are coming to the court now. As the Besaki Bhattacharya judgment which has been read before your lordship, the argument of delay and leakage has been turned down on the ground that the petitioners who filed petitions in 2021, the fraud itself of the state, RPSC and others was uncovered only in 2021. Here, my lord, they themselves say in Kailash Chand case as well as here that spate of FIRs were already registered Final reports have been submitted in 7 out of 10. Yet they don't treat. It is a clear case, my lord. Thereafter appearing in physical examination and appearing in interview, and only on being unsuccessful, filing this petition without any explanation whatsoever. Can this petition be entertained, my lord, at the behest of Kailasthand, etc., who have made all the submissions and filed every record before the court? Can that be allowed, my lord? Now what he does, after filing this 2023 petition, my lord, he remains silent. Only in February 2024, 5 that this petition gets tagged with the Kailashthand's petition. Up to February 24, 2025, no attempt, my lord, whatsoever to get this petition heard. नवंबर 21, 2023 के बाद सीधा सर फरवरी 24, 2025 में हो गया था।
He has also moved application for early listing of them.
My lord, on date, my lord.
It was in 24.
Yes.
He moved an application.
But then, my lord, we already filed a reply in this case. Thereafter, he did nothing.
You appeared at the first date.
Mr. Rajesh Mercy filed reply in
Yes.
earlier additional advocate.
Yes, he appeared.
And filed a reply, my lord.
He was given time to file reply
He filed the reply, my lord.
several times. Then the court passed. His basis is that.
And then what
the
happened,
interview.
my lord?
He appeared in the interview,
Interview, my lord.
and later on,
Remains
the report which has come on record, which he has learned, that the concerned person who took his interview.
Yes, that report didn't come, my lord. That's
That
interesting.
is here.
No, your lordship may just see me.
Babulal Katara, who is involved in the paper.
No, this he says in August 2023, my lord, but the report which was...
Twice the writ petition mentions that Babulal Katara, his main ground is,
No, your lordship may read.
who was member of the interview board,
It's
has
interesting.
been arrested and found
No,
to be
what
involved.
is... Just a minute, let me
This
explain.
is what he says in
This is what he says, but in what manner he says, let me explain, my lord. He files this FIR of Bekaria case, my lord, which they have been saying, and it has been dealt with in the SOG report also. Your lordship may see this report, my lord. There is not even name of Babulal Katara mentioned there. What happened there is, my lord, some Mukbir, my lord, told that there is a bus where this examination preparation is taking place. So bus was taken hold of, where, my lord, certain question papers and answers were found in possession of that. But by that time, my lord, the persons who took hold of the bus, FIR says this, my lord, it is report by the police that we do not know whether this RPSC will be circulating this very paper only. So unless it is confirmed from RPSC that this very paper is being circulated, no action could have been taken, and therefore this bus was taken to the examination center for allowing them to appear in the examination. But before that, RPSC itself, my lord, put the examination in abeyance, didn't hold that paper, and therefore, my lord, nothing happened on that date. But when RPSC gave the paper to the police that this was the paper and the answers, then it was found, my lord, 70-80% of the answers which they were reading in the bus are the same, or the questions were the same, my lord, 70-80. This is how the FIR has been registered. Name of Babulal Katara is not there. What he says is, your lordship may read, if the SOG would have conducted the examination, para 10, my lord. It is worthwhile to mention here that one of the member of Rajasthan, Babulal, was also included in interview panel. Further, RPSC member Babulal Katara has been detained by SOG and ATS Rajasthan, Jaipur, because of his involvement in competitive examination in 2022. Further, in this regard, FIR bearing was registered. This is what he says, my lord. And he ground says that if it would have been done, C ground, respondent has not conducted the fair and time-bound investigation in FIR and 227 at police station Bekaria due to failure of investigation in proper manner. RPSC member who is involved in the paper leak later on detained by SOG has participated in interview. Now this is, my lord, last week of December, this FIR which I told to your lordship was registered. Interviews have taken place from January to May 2023. And SOG was not involved at all. SOG came into picture in December 2024 when SIT was constituted, and in March 2024, this writing all these things, my lord, are pre-emptory and prematured in the sense that no material, and he says that this investigation will not be possible by regular police, and therefore CBI investigation should be done. He doesn't believe that the SOG, etc. Ground F, he says, and then prayer is for transferring it to CBI. So it was a case, my lord, filed without any material at that point of time, after having failed in the examination, seeking an investigation by CBI in matters which were already charge sheeted, my lord. In 5 cases, charge sheet was already filed before he filed the petition. And he was very much aware. So in my humble submission, my lord, then what they do, they consistently this maintainability issue was raised before learned single judge. And when Kailashan and party thought that they may fail on maintainability, this report of SOG, etc. were got filed in May 2025 in this case by way of an additional affidavit. और आप प्रेयर देखें साहब प्रमोद की कौन सा एग्जामिनेशन कैंसिल करना ये भी ठीक से नहीं लिखा है. आप देखें साहब प्रेयर ए कैंसिलेशन ऑफ एग्जामिनेशन के लिए इट हैज़ नॉट बीन इवन अमेंडेड. ये नहीं लिखा कि 2021 वाला एग्जाम कैंसिल कर दें. बेकरिया का कैंसिल करना है कि ये कैंसिल करना है कि पहले के कोई सिंपली सेट असाइड द एंटायर प्रोसेस ऑफ एग्जामिनेशन. प्लाटून कमांडर फॉर द पोस्ट इन राजस्थान पुलिस कंडक्टेड बाय रेस्पोंडेंट नंबर 2 and 3 when it was conducted in 2010, then 2016, then 2021. Can such prayer, my lord, without mention of the examination to be cancelled, and such prayer could have been granted by reading in context, my lord? And then, my lord, he filed a RTI application in June 2023. There also he doesn't say that the examination is vitiated, etc. He simply applies to see as to who were in panel of the interview. Annexure 13, June 2020. After declaration of result, he doesn't say that you give me material of, or it is no representation whatsoever. And directly coming to the court for cancellation of examination, the year of which is not mentioned even in prayer meeting. So this petition also, my lord, would have gone for the reasons which I have already argued. Then, my lord, once this petition of Kailashan comes again, one more petition which is there, Manish Chaudhary and SAW, is 218. The kind of petitions your lordship may see how they have come approach the court. Item 218, my lord. He didn't succeed, my lord, even in written examination. To say that other petitions are there for this maintainability issue may not be looked into would be doing injustice, my lord. This Manish Chaudhary's petition, your lordship may be pleased to see. It's a council created petition, my lord, and it will surprise your lordship, my lord. The post has been imposed in another case where this very council, my lord, filed a PIL saying that there is no post of deputy chief minister and therefore their appointments be cancelled. The cost was imposed, and 2 days before your lordship has seen that he was craving that since there is a sickness of my mother, etc., and then your lordship say that the background seems to be not to be of a person who cannot afford 50,000 cost. Then he said that it's a background. That is the man who files this petition, my lord, saying that the petitioners made representation. All these things were told, my lord, to the honorable single judge, and that's why nothing finds place in the main judgment with regard to these arguments in these. Your lordship may see, my lord, the fact mentioned at page 24. Now on oath, my lord, a statement is made at page 24, para 17, second part, my lord. Subpara 2, my lord. The petitioner has also
Page 17.
yes, para 17, page 24, miss. Now he mentions, my lord, filing a petition in 2025, he says the petitioner has also submitted a representation dated 5/8/2023 through his counsel to the Honorable Chief Minister and higher authorities, but no heed has been paid by the respondents. Copy of the representation dated 5/8/2023 is enclosed as Annexure 7. The lordship may have Annexure 7, my lord, at page 107. It is a representation given by the counsel himself as an applicant. No mention of any of the name of the petitioner or the representation being submitted on somebody's behalf. And it is with regard to, the contents are with regard to, of course, my lord, this examination, and saying that only from Jalore there were selections and therefore let the things be examined. But it is 109, your lordship will find, my lord, it is O.P. Solanki counsel who files this petition on behalf of the petitioners, makes a representation himself and pleads that it was done on behalf of the petitioners through counsel. Then, my lord, the next is the petitioner has also sought information under RTI Act through his counsel regarding said selection. Your lordship may see that application at Annexure 8, page 110. It is on nobody's behalf. The counsel himself applies for certain information, my lord, in August 2023. So, and then, my lord, another, even though he mentions about this only, another RTI application which is again by somebody else, page 112. This is Advocate Rahul Tank. So, my lord, those who make false statements, makes a RTI application or a representation, even if it is assumed to be on behalf of the petitioner in August 2023, files a petition in February 2025, after persons have been trained, and the petitioner is a person who failed in the written exam. He didn't secure the qualifying marks. No harm has been done to him. He himself pleads that he couldn't succeed in written examination. So how can, my lord, these additions of petitions to a main petition in which submissions are made, which is treated as a lead case, which is as a matter of fact not maintainable, how can these two petitions save,
He says that if they would not have passed, then he would have come in the merit. No?
my lord?
These people.
No,
would
no,
have taken-
at written examination, no.
The written examination.
So,
they
minimum
go
qualifying.
out, then other
No, my lord. The
the
process is,
percentage will come down. No?
no, my lord. Minimum qualifying marks are prescribed in written examination, and those who secure minimum qualifying marks, they go for the physical examination. So he didn't secure even those minimum qualifying marks. It is not, my lord, that merit list is prepared and then physical exam. Minimum qualifying marks have to be secured. There is minimum qualifying marks further also, my lord, but in written examination, he doesn't qualify because he fails himself, not because of not being in merit. So these are the kinds of persons, my lord. Yeah. No other submission which has been made, my lord, time and again, that the government wanted to take a decision and court allowed it. That is not the case, my lord. Citing the judgment in case with regard to as to when mandamus can be issued, we said that the petitioners have now come telling the court that the government is doing everything. Arresting people, SIT has been constituted, report is being submitted. They are doing everything, and therefore mandamus be issued to cancel it, or the examination be cancelled. So we relied upon, my lord, the judgment in case of State of West Bengal of Nuruddin Malik, which says that in such like matters where administrative decision has to be taken, a petition can be filed only for issuing a mandamus to take a decision where it is required by law to be taken. But the court cannot itself take a decision. In that case, the court said that instead of allowing to file a fresh petition, we will keep the petition pending and ask the authority to take the decision. When we said that this petition for cancellation as such is not maintainable because no slackness on the part of the government is being told, then in order that I am not reading, my lord, all these things will be revealed from 21st February 2025 order, where tooth and nail the maintainability of writ petition was opposed, and it was said that your lordship examines the decision when it is taken on the ground of illegality in decision making process, does not take the decision itself. On those arguments, and when said that the government is prepared to take a decision, we were allowed to take decision, which we have taken, and it is not challenged. This is second part, my lord. And now the third thing which has been argued, my lord, your lordship may be pleased to see, the judgments we have cited that the interdepartment.
Ask you something relating to what is the position as on today.
Yes, my lord. I have asked them to prepare a report. I am told that by evening they will supply it to me, my lord. Let me see what the report they bring, and then I will come back to your lordship, mention in the morning as to what is the plan. They are preparing a factual report, my lord. I asked before entering in the court, they said that they will be able to make it available in the evening at my residence. And if necessary, my lord, tomorrow I can bring to your lordship. Or tell what they have brought, if it is worth filing.
Whatever, you'll have to give us.
Yes, whatever they bring, my lord, I will come early morning, my lord.
It should be in the open court. They should also know about what.
No, my lord, there is the problem.
We will not want what you are.
No, what we said earlier also was, my lord, there people.
We are not asking you to give them a copy.
Yes.
But let it be what you want to tell us.
Yes, of course, in their presence, my lord, there is no problem. No problem. Then your lordship may be pleased to see, my lord, that they have, as your lordship is seen from the judgment of Honorable Single Judge, what has been told by them is that There was a SOG report where 18 chapters were there, and this has been said, that has been said. There is, the state government is not disowning that. The question is, while exercising the power of judicial review, whether your lordship will be relying upon intermittent administrative communications between the departments, which is not a final decision taken by the government and communicated to the court. And I have, my lord, cited judgments in this regard from flag 23, 24 and 25. This Sodhi Sukhdev Singh's case, is Shanti Sports Club case and Lakshmi Narayan Das case, that these are communication meant for arriving at a decision between the departments. My lord. They cannot be laid as a foundation of the judgment. Number one. Secondly, my lord, your lordship has seen that this SOG report of August 2003 is not a charge sheet filed in the court, my lord. It is based on certain charge sheets already filed by SOG, 2 charge sheets already filed in other police stations. On the basis of this, an opinion has been formed on various issues based on the investigation which took place by that time. And my lord, look, every human being, my lord, who is whether an investigating agency or a decision making authority, whatever material comes and the influx of the material which came by that time, it was seen, my lord, as if there is something bigger has taken place and therefore a report is given. On the basis of what the investigating agency said, my lord, the persons who had to make opinion, they made the opinion, my lord. But in the meanwhile, from August to May 2025, it is, my lord, almost 5 months of 2024 and 5 months of 2025. June 2026, my lord, about 11 months investigation was already there, and my learned friend has rightly marked those charge sheets which have been filed. Now it is an issue of perspective, my lord. One is seeing that, see, more persons have been arrested. See, more material has been received. Now at least you cancel when you had the opinion earlier that it can be cancelled. Why not now? Why fall back on the opinion which you have made earlier? This is one way of looking at the things, my lord. The other way is that the assumptions which were made at the time of preliminary investigation of 3 months by August or 4 months by August 2024, if we could not connect the dots during the course of investigation except saying that these are the persons guilty, but we didn't, if it has not been found that it has circulated so much that it would be impossible to segregate the tainted and untainted. In that event, my lord, if the investigating agency itself says, because they have been investigating, they had certain expectations of getting material on the basis of it, which it can be said that it was so widespread that the sanctity itself of the examination goes. If the investigating agency itself comes to a conclusion, my lord, that what we are finding, we are not able to extend our hands throughout the state. We are only able to nab the persons who are really guilty. And that's why if some arrests are more made, my lord, some more will be arrested. But then it will result in segregation of guilty and tainted and non-tainted, if that is the opinion, my lord. How can, my lord, whether this honorable court will, as a matter of fact, sit in appeal with regard to the opinion of the investigating agency of its ability to segregate tainted and untainted, and look into the entire material and say that no, you are not right, your opinion is not correct. That is not the scope here, my lord. And this is what in Vansika Yadav, my lord, the Honorable Supreme Court has done. It was all India examination. It was with regard to NEET, medical examination, and there were reports submitted. But the court said that even if we go through all this, we can't say that it was so largely spread that the examination itself is vitiated. This is why, my lord, your lordship, if we just count Bluetooth is used, mobile is used. So I am making the last submission, my lord. It will be setting a very bad precedent. If the court starts interfering on the ground that there are gangs operating, who, my lord, indulge in putting dummies or getting the papers leaked and earning out of it. Because unless, nobody can say, my lord, that every person who is doing this illegal or heinous crime outside, they will all be behind the bars and will never come out. Or there will be no further gangs. So that is not the, that is why the court says it is systemic malice, which is important. It is not, my lord, if the criminals will continue to operate, examination after examination will be held, and people will be arrested, and people will be coming and asking your court to cancel the examination because this gang is involved, that gang is involved. How faith can be reposed in this? This is the condition of the state or the country, my lord, where criminals do their job, the crime preventing agencies do their job. Still there is no elimination of crime. So therefore, my lord, being influenced emotionally by saying that the trust of the people should be so high in the examination that everybody feels safe, maybe, my lord, the situations are not such. If the gangs have been involved, my lord, coaching institutes we are not going to close. If everybody is doing their job, the question is how the RPSC or the examining body has taken care of seeing that a fair examination takes place. If there have been breaches somewhere, that cannot be cause for cancellation. Otherwise, my lord, what they are saying earlier on lesser arrest, the examination has been cancelled. So on comparisons, my lord, that is what the argument being made. Today it is cancelled. Tomorrow they will say, see, gangs are still there. The papers have been leaked, dummies have been put, and in such situation, examination has been cancelled, so cancel it now. And who will be coming to your lordship, my lord? Those who do not succeed, those who didn't put the required labor or do not have that talent of getting selected, they will be piling up petitions after petitions before lordship by saying that crime is taking place in the state and therefore you cancel the examination. So your lordship has to examine as to whether there has been systemic malice and failure as in case of Bhattacharya's case. Here, my lord, what is the involvement told? He has read the papers from charge sheet in which Babulal Katara's and Ramu Raika's involvement has been found. Now, the investigating agency didn't find anything more than getting their two children selected. If, my lord, Babulal Katara allowed Ramu Ram Raika to take, scan the papers, who gives to these two children, Ramu Ram Raika, Babulal Katara, both the children are behind the bars. Is there any material read from that charge sheet, my lord, which indicates that no, Ramu Ram Raika having got it, he earned a lot of money. Whether your lordship will be travelling on conjectures and surmises by saying that who knows how many people have seen it, or there should be, my lord, material to reach to the conclusion that so many persons have benefited, they may not be exactly identified, but there must be material before, if the investigating agency finds that so and so has been benefited, that is being arrested. So all these charge sheets only show, my lord, that we have been vigilant, we have been investigating, we have been booking those who are guilty, and there is no further material to show that it was so wide. It is 21 to 2026, 5 years, my lord. How many people came to your lordship saying that we know that it was widespread and this examination is nothing but a farce? They do not come, my lord. Only this petition of 2022, that withdrawn, and thereafter, when the government finds and nabs the guilty, my lord, they come and want to take advantage of that. That should not be permitted. Deeply obliged.
Mr. Prasad. One was with regard to the surprise test which was conducted by the SOC.
May I take a lordship's leave?
One argument of mine was that for purposes of segregation itself, one of the methods adopted was to hold a surprise test. And on the basis of that surprise test, I submitted that they did arrive at a conclusion whether the selected candidates had
The
in,
surprise test result was not
no,
declared.
no, yes, that is precisely what I am submitting. That in the order sheet of the honorable, the learned single judge, when the proceedings were held in camera, Mr. V.K. Singh was called, and Mr. V.K. Singh said that marks were not allocated. It was not actually a surprise test to do that. But your lordship, you may kindly see page 603 of the file, my lord. In Amar Singh's case, my lord, 603, in which my lord Kailash Kumar was arrested, annexure AA1, the additional affidavit of petitioner in Amar Singh's case. The document starts at page 602, my lord.
603.
Yes, 603 is the relevant portion. This was the proceedings,
Before the single judge.
the charge sheet that was filed, my lord, the remand that was obtained, remand obtained of
अभियुक्त की
Kailash
जमा
Kumar.
तलाशी से प्राप्त शुदा
Uh,
603 is the part of the charge sheet. Start from page 596.
No, my lord. This is the additional affidavit, my lord. This is the additional affidavit filed by Amar Singh on 24th of November 2025, my lord.
Maybe appeal. Is it part of the appeal?
Yes.
Yes, sir. Part of the appeal, sir.
Appeal. It's 103, yes.
This is the remand sought of Kailash Kumar.
अच्छा अभी क्या लिखा था कार्ड लिखा रहा है क्या अलग से कोई आज के लिए
The lordship got this one? Starts at page 602, my lord. The remand application filed in the court, 602. And at page 603, the last paragraph, my lord, starting with प्रकरण में अनुसंधान प्राप्त गोपनीय आसूचना से ये सामने आया. Now, my lord, just about 10 lines from there, my lord, कैलाश कुमार ने उपनिरीक्षक भर्ती परीक्षा
SAW.
HAW of अमर सिंह.
Yeah. Give me special opinion. Additional affidavit. 595 Second affidavit. Yes, what do you want to
So,
show?
page 603, my lord, just about 15 lines from the bottom, my lord, where it says, उप निरीक्षक भर्ती परीक्षा 2021 के क्रम में, your lordship got this one? SOG ने प्रकरण दर्ज होने के बाद अनुसंधान के दौरान राजस्थान पुलिस अकादमी में प्रशिक्षण प्राप्त कर रहे प्रशिक्षुओं का उक्त भर्ती परीक्षा के लिखित परीक्षा में आए प्रश्न पत्रों के अनुसार पुनः परीक्षा ली गई थी, जिसमें कैलाश कुमार ने प्रथम विषय हिंदी में 100 में से 57 प्रश्न सही हल किए, 37 प्रश्न गलत हल किए एवं 5 प्रश्न हल नहीं किए। द्वितीय विषय सामान्य ज्ञान में 100 में से 48 प्रश्न सही हल किए, 36 प्रश्न गलत हल किए तथा 14 प्रश्न हल नहीं किए। इस प्रकार उक्त पुनः ली गई लिखित परीक्षा में सही हल किए गए प्रश्नों के प्राप्तांकों में से गलत हल किए गए प्रश्नों का 1/3 अंक काटने पर कैलाश कुमार के हिंदी विषय में 200 में से 90 अंक तथा सामान्य ज्ञान में 200 में से 72 अंक तथा कुल 162 अंक प्राप्त हुए, जो उसकी उप निरीक्षक की लिखित परीक्षा के कुल प्राप्तांकों से करीब 186 अंक कम है। और इस प्रकार कैलाश कुमार उप निरीक्षक की लिखित परीक्षा में प्राप्तांकों एवं विभाग द्वारा उन्हीं प्रश्न पत्रों से पुनः ली गई परीक्षा में हल किए गए प्रश्नों में भारी अंतर आया। कैलाश कुमार से पूछताछ के दौरान संधि विच्छेद के बारे में पूछा गया तो वह सही उत्तर नहीं दे पाया तथा हिंदी की मात्राओं में भी काफी अशुद्धियां पाई गई। इसी तरह वह सामान्य हिंदी एवं सामान्य ज्ञान के साधारण पूछे गए प्रश्नों का सही उत्तर नहीं दे पाया, जबकि कैलाश कुमार के उप निरीक्षक की लिखित परीक्षा में हिंदी में 200 में से 180.94 अंक प्राप्त हुए हैं तथा सामान्य ज्ञान में 200 में से 167.89 अंक प्राप्त हुए हैं। कैलाश कुमार के विरुद्ध प्राप्त गोपनीय आसूचनाओं एवं अनुसंधान के उपरोक्त तथ्यों से प्रथम दृष्टिया स्पष्ट हुआ कि कैलाश कुमार उप निरीक्षक भर्ती परीक्षा 2021 की दोनों पारियों की लिखित परीक्षा से पूर्व पेपर लीक गिरोह के मार्फत सॉल्व पेपर पढ़कर दिए है तथा वह अवैधिक रूप से मेरिट अरेस्टेड ऑन दिस ग्राउंड and Lord please to see prosecuted. So it is absolutely incorrect, Lord, to say that no marks were awarded. Each of the candidates, Your Lord, please see, their answer sheets were compared with the answers given by them. But not only this, Lord, and another, Lord, additional affidavit of petitioner in Kailash Chand Sharma's case before the learned single judge, my Lord. I'll read at page 2229, it is there, my Lord, and at the relevant page 2233 is the कार्यालय अतिरिक्त महानिदेशक पुलिस एटीएस एवं एसओजी राजस्थान जयपुर का प्रेस नोट है दिनांक 8/8/25 का। इसमें वन सत्येंद्र सिंह यादव उसके खिलाफ इन्होंने कार्रवाई करी है और उसमें ये लिखा है सर उन्होंने एसओजी में प्रकरण दर्ज होने के बाद अनुसंधान के दौरान राजस्थान पुलिस अकेडमी द्वारा प्रशिक्षण प्राप्त कर रहे प्रशिक्षुओं का उस भर्ती परीक्षा के लिखित परीक्षा में आए प्रश्न पत्रों के अनुसार पुनः परीक्षा ली गई थी। सत्येंद्र सिंह यादव उप निरीक्षक की लिखित परीक्षा में प्राप्तांकों एवं विभाग द्वारा उन्हीं प्रश्न पत्रों से पुनः ली गई परीक्षा के प्राप्तांकों में भारी अंतर पाया गया। He was also arrested. So let this surprise test, your Lordship, please to see. Mr. V.K. Singh, of course, was a member of the interview panel also. Why he did he submit before the learned single judge that marks were not awarded when the police record itself says that marks were awarded, they were these people were segregated on the basis of that and arrests were made on the basis of that. The page 2233, sir, in Kailash Chand Sharma's case. 2233. Annexure 60, my lord. Annexure 60. In the original writ petition, my lord, of Kailash Chand Sharma.
2233. Yeah.
It starts at page 2229.
Press note.
2229. The press note. Yes, my lord. Press note. The press note. Specifically mentioning सत्येंद्र यादव के परीक्षा में प्राप्तांकों को कंपेयर किया गया उसमें बहुत कम पाए गए and he was arrested on that account.
Yes.
Then one of the arguments was made was that since the paper was sent through WhatsApp, it may have reached thousands and thousands of persons. Nobody knows how many would have reached it. Kindly appreciate the modus with which the WhatsApp answers would have been sent. The candidates are already in the examination hall. They could have been sent by Bluetooth. Persons who having mobile phones, they could have access to it. But only 2 persons have been arrested. Kindly appreciate that. That if it was so large scale, there may have been, they may have adopted these means. There may have been gangs operating, undoubtedly, as Mr. Rajendra Prasad argued. That is one aspect of the matter. But how many people took advantage of that? How many people have been up till now, over a period of 5 years, been identified? Only 2 people who have been arrested, who have taken advantage of the answers given to them on Bluetooth.
Yes, anything to conclude.
Third, Your Lordship, as Mr. Rajendra Prasad submitted before Your Lordship with regard to the involvement of RPSC members was there, yes, but limited. For example, Your Lordship, please to see Mr. Ramuram Raikas, both the daughters were given the paper. Ramuram Raikas, one of the daughters' allegation was made that she was asked to come in a white sari. The other daughter failed in the interview. Only one daughter passed. It is not as if, Lord, things have gone beyond proportions. It's only advantage taken by a few people. One of the daughters was selected, the other daughter was rejected in interview. Then, Lord, even Babulal Katara's own nephew, he has not been selected. So, Lord, not defending, obviously not defending them. They must, having been found guilty, even if they have sent it to 1 or 2 or 10 people, they must be found guilty. If they are found guilty, they should be prosecuted. There's no doubt about it. But can it be said that it's such a systematic, Lord, malice that the entire exam should be cancelled? In my humble submission, charge sheets are there, charge sheets have been filed, continuously. The next argument that I would make before Lordship is that the learned single judge erred, my lord. The first communication, the SIT report, which was first submitted to the learned single judge, was only, a Lordship pleased to say, an internal correspondence between the state government, the SIT submitted to the state government, no decision had been taken. The second, your Lordship pleased to see recommendation, the state government had taken a decision on the second report. Now, the learned single judge has not dealt with it at all. He has not said that the second report is incorrect in any manner, or that arbitrary reasons have been given therein, or non-existent reasons have been given therein. But because ultimately, your Lordships have to see the process that has been adopted by the state government. At the time when initially the FIRs were lost, a few charge sheets had been filed, and that at that time the SIT report was submitted. Yes, at that point of time, they may have taken a call as to what should be there. Recommendations may have been made. No decision taken. But that cannot be made the basis of the decision of the learned single judge, especially when the second SIT report has already come and no comments on that SIT report. One could have understood if the learned single judge would have said that the second SIT report as compared to the first SIT report cannot be accepted because of XYZ reasons. But he does not say that. He has gone beyond the jurisdiction as far as judicial review is concerned of the decision. In my humble submission, considering the nature of the allegations, you'll not pleased to see, it's 100% case, you'll not pleased to see, where the segregation can be done and has been done.
All.
That.
In 30 seconds, only one fact which I would like to bring to the notice of all. Of concealment of the facts which the petitioners have made and which the documents have not been completely submitted. Out of the 25 petitioners in case of Kailash Sharma, one person, Chetan Prakash Meena, who is at serial number 20, he's a member of the investigative team of the SPC. He himself is investigating. He's a member of the team.
Chetan?
Chetan Prakash Meena, he's a petitioner number 20. in the writ petition filed by Kailash Chand Sharma. Is a part of the investigation team and a witness also. He failed in this examination. He is a and when the documents are filed, charge sheets, the list in which his name is there, that is not submitted by the writ petitioners in the writ petition. That part of the charge sheet is missing. Then petitioner Kailash Chand Sharma is also a member of the police service. He is a constable. Lordships will further find that out of the writ petitioners, 25 writ petitioners, in the list of witnesses, as many as 6 persons have been made witnesses in the
6 persons among writ petitioner.
yes. Their names are, if the Lordship permit, in order to save time, I can pass on the chart.
Yes,
their names.
that would be.
And earlier also I submitted a chart before the Honorable Court when I was making submission that these were persons who have been selected. They have qualified other examinations also, and kindly consider and appreciate that a re-examination was conducted by the SOG, as Mr. Kamlakar Sharma has argued, and in that re-examination, those who did not secure good marks, they have been separated, and therefore a process of separation has been adopted by conducting a re-examination also. But I am principally on the issue that one of the writ petitioners is a part of the investigation team. That is all.
Is it so, Mr. Mir?
I think he's posted in SOG, not part of the investigation. So, not of this investigation, not of this investigation. I can
He was
confirm.
a witness also.
I will confirm, sir.
Sir, that's why.
Not part of this investigation, but he's posted in SOG. That was raised by the state.
One Priyanka Chaudhary, who is witness. Manju Ranwa is a witness.
Sir, we have list of witnesses which they have not filed. Along with the incomplete charge sheet was filed.
It may be the reason why SIT report is with them. How could the SIT report be with them, with the writ petitioner?
Moment the SIT report was there, the man supplied to them, himself petitioner, and filed by way of additional evidence.
I mean, that's not I think well, the only everything else is covered. The great emphasis was on the first report. In fact, Malad, there's a whole list of the discrepancies in the first report. There's no purpose in getting into where the discrepancy or not, but the purpose is if there are a whole lot of discrepancies, therefore the subsequent reports become even more important. And there is no reason why they should not be read in. There is no reason given in that why support will be drawn by the petitioners only from the first report. That in any case, the fundamental principle of investigation is that until things keep coming up to the surface, they will keep going. And once there is a firmer opinion which comes in with more material having come in fact, it's the other way around. If an opinion has come in after further evaluation, then that will take more precedence unless it is shown to be malified or without considering the earlier one. So the entire emphasis of the first report only, we've got a whole list of it, that therein, obviously there are discrepancies therein. They have shown something, actually I've got a whole list prepared, but that's not really the point in here because my lord's not sitting in judgment of what has come in by way of a chart sheet and the reports that have come in. So therefore, my lords, the question here was of whether the exam is to be cancelled or not with this factual background, not whether the facts are certain, but at this point of time, there could be discrepancies, etc.
That is not.
That is. So therefore, my lords, the whole emphasis on showing that discrepancy, that there are people who are culpable of misgivings, is not really answering the question that is here. And that, my lords, there is no answer to the judgment of the Supreme Court, which we had already, my lords, had submitted on the earlier occasion. And my lords, Joginder Pal's case, which evaluates of when it is to be cancelled and when not to be cancelled.
That's it.
And my lords, in Jharkhand, Jharkhand High Court had taken a similar view. And therein, my lords, when it traveled to the Supreme Court observed that if any further criminal prosecutions come in, so these appointments will always be subject to that if everything comes in. So, my lords, the one submission that came in, that there are still certain people who are not being apprehended or coming. So, if at all that comes to the light, that's given in protection, my lords. I mean, protection in the sense that they will always be prosecuted and can be terminated at their state, because if there's a possibility that somebody may not have been. That judgment, my lords, I'll pass on. Jharkhand detailed.
That if any person is subsequently found to be
Case for subsequently, but this is what the Supreme Court says. By dismissing the appeal, my lord. This is the, my lords, sorry. So that, my lords, one. And my lords, there was one submission with respect to that this is still absconding. In this case was Priyanka Goswami. She's been granted anticipatory bail by the Supreme Court, my lords. So, my lords, that's, if by judicial application of mind of protection is granted, that cannot be made on a basis that some key person is I've already given it. But that's a detailed judgment, the Jharkhand judgment, and then this is my lord by dismissing that appeal.
The operative process number 5, it says, if in the investigation of SIT some more successful candidates are found involved in malpractice, the state shall take appropriate action against the said candidate. So that's always an ongoing process.
Absolutely.
Has been given to Kundan Pandya subsequently given to Sudeep Kumar Raka, Purushottam Dadi, Nazma Yadav, who are the seniors of that section K, and they are given to the government statement. That details comes in Article 7J.
Identified persons all apprehended.
It may be that it has been substantiated prior also.
So that's an absolute conjecture. And in fact, my lords, that is what was specially answered, my lords, in Joginder Pal, that the establishment will have to be that it can't be done. Not that it open-ended. Great, my lord.
One is carrying remark that we made against without hearing them on the.
We have already heard that part.
And
It's not here. There is no rejoinder required here.
it's one line only. 16 section. Section 8. Even if
Leave to application.
section 5.
Section 5 allow delay condone. Application for grant of leave is allowed. Cases have been heard at length. Judgment reserved. Defects waived. Service is treated as complete as counsel appears for all the parties. Respective counsels appear for all.
Only one submission.
May I report that list?
Tomorrow,
Yes.
he may be here so that.
Yes.
My lord, do we give that list that one petitioner is the part of the SIT investigation team and 7 others are witnesses or constables who appear to that list?
And at the outside, when the hearing were taken place, my lords, the affidavit with the report